Hi there, and welcome to Friday Live. I'm your host, Strata lawyer Amanda Farmer. We're here on a Friday catching up on all that's been happening in our Strata space. It's great to be here with you after a couple of weeks. How's your week in Strata been? I've had another busy one. I know things are ramping up for our Strata managers in particular as we head towards the end of the year, getting into that time for professionals where there is no 2026. Everything just has to be done now. Nothing can wait. It's going to be a little bit like that for a few more weeks, guys. Hang in there. I am here experiencing it all with you. NCAT hearings, got a hearing scheduled for next week, prepping for that, doing some affidavit drafting, new applications being filed. There's a lot of litigation on at the moment. I think it was Rena Van Alst I was talking to. This might have been off air after we recorded our latest podcast episode. Rena was saying it's just the tribunal litigation is really ramping up. Everything that she's working on as a Strata manager, or most things she's working on as a Strata manager, have something to do with tribunal litigation. I said it's the same in my practice at the moment. Strata lawyers, very litigation heavy. What's the deal? What's the deal out there, guys? A lot of people suffering in Strata and having to commence proceedings. I think our New South Wales Tribunal is getting a little bit backlogged. Mediation in particular, they're now giving out mediation dates for next year, for January next year. I think we've had our last December dates allocated for mediation. So just to prepare you if you're heading down that track. And if you're involved in tribunal litigation, if you're thinking about maybe having to be involved in tribunal litigation, you're definitely in the right place. Lots of experience, knowledge here for you, and a lot of resources, including a really special free online training that I only roll out a couple of times a year. I'm going to let you know all about that a little bit later today. Give you the date, give you the link to get registered so you can take part in that one. Lots of you here. Welcome on this Friday afternoon. Hi, Sean, David, Thrasilla, Sean O and Sean M are here. Suzanne, Sean saying it's so close to Christmas. Yeah, I was doing a training earlier this week with some Strata managers, and I was saying, back when we did our last webinar a few months ago, in February, it was February, and I had to remind myself, it's now November, Amanda. That was not a few months ago. That was almost a year ago now. Hey, David, how are you? I love you. You're all popping up twice here because you're all saying hello to each other. Great. Hey, Lee. Lovely to see you popping in there. Our agenda for today, let's give a nod to the podcast episode 468 that went out. We're going to have a look at that one. Lots in that one if you haven't had a chance to have a listen yet. It was a Rena and Amanda episode, which so many of you tell me that you love. We are going to talk about a case. I have a case for you. This week's case coming from Queensland. Some of you might have heard about this one already if you've been doing the rounds on LinkedIn, if you're connected to the same commentators, I'm going to say that I am, you might have seen this one being discussed on LinkedIn. I'm going to take a deep dive into it. It was so timely. It is so timely because this issue that arises in this particular Queensland case is cropping up for me and no doubt for you on an almost daily basis these days. Yes, the case is about AI, artificial intelligence. We're going to have a look at it. And as I said, I'll give you the link to register for my next free training, which is all about how to navigate the tribunal, the litigation process successfully, particularly if you are a self-represented litigant. So we will get on to that one. Josephine, Colin is here, also back in NZ. How you doing, Colin? And Sean saying helping a neighbour with prepping for an NCAT application, and they asked me about something they'd found, which was AI hallucinating sections of the Act. We are spending so much time on this, aren't we? Correcting these mistakes, misconceptions, well-intentioned, and I want to be a little bit sensitive, a little bit gentle here with those who are trying their best to do their legal research, to use AI to help them with their cases, to help their lawyers, to help their strata managers, to help their neighbors. But it ain't all that helpful when what is being presented is incorrect. Fake doesn't exist, is an hallucination. So that's a big part of the reason, John, why I wanted to bring this to the chat today. Good afternoon, Daryl. How you doing? All right. I think everybody's here. That's our roll call. But if you're coming in a little bit after our start time, feel free to drop me a hello here in the comments if you're catching the replay. I love to see your hellos as well. Podcast episode number 468 released this week. Rena brought to the table her challenge about building managers and their role, their duties, in particular, the way in which they keep or do not keep records. Not the first time that this frustration has been raised with me, and there are, I'm sure, some managers, some committee members out there who can relate to this. If you're lucky enough, and I think you're really lucky if you're in a building that has a building manager, if you're lucky enough to have a building manager, it's often the case that that building manager is charged with the task of getting quotes for work to be done. It is also often the case that that building manager is operating off their own software platform, or a software platform that they subscribe to and that they pay for, and that is part of their service that they bring to the table for a building. And that means a lot of documents are saved to what is technically, legally, the building manager's software, the building manager's platform. If that building manager terminates their contract, if their contract is terminated, they don't renew, they are no longer your building manager, it's very often the case that you don't have access to those documents anymore. Those documents walk off with the building manager. Rena shared that exact example in this week's chat, saying there was some work that needed to be done on fire doors. Rena was quite sure, because luckily she was the manager 6 years ago, that some of that work had already been done. She was looking for a record of it, couldn't find it, and had to dig back through invoices, I think, that she had paid for that particular community to find evidence that, yeah, we did actually replace those fire doors. The problem being that the building manager had not provided copies of quotes to the strata manager, so the strata manager could then keep those documents as the professional carrying out that task of being the custodian of the owner's corporation's records. So in the chat, we talked about ways that we might deal with that, how you might deal with that in your contract terms. When you're entering into the contract with the building manager, you might have an obligation in there for the building manager to each month or each quarter, whatever suits your building, to provide a link of all documents that they have obtained, created, received on behalf of the owner's corporation. Send that link to the strata manager. Strata manager can hit a button and save that to their filing systems, making sure that we have regular building management reports at our committee meetings, and that those reports are comprehensive, setting out exactly what it is that the building manager has been doing. Important to stay on top of those kinds of things, because you don't know until you need it down the track what it is that you don't have. So have a listen more to that topic in that chat. We also talked about the recent reform in New South Wales, legal reform specific to levy recovery and payment plans. When do we need to offer a payment plan? Why should we be offering payment plans? Which sections of the legislation, new legislation, have commenced, which are yet to commence? A little bit of confusion around that I hope has been clarified in that chat. What I have heard since, I'm going to say, speaking a little bit publicly about this section of the new legislation that hasn't started yet, Section 86 2AA, let's get that right, Section 86 2AA, that is made, the legislation has been made, hasn't commenced. That's the section Rena and I talk about on the podcast. I've talked about it here on live previously. The section that requires an owner's corporation to first have offered an owner a payment plan and to have an order of the court or the tribunal if the owner's corporation wants to recover the expenses that it has incurred in chasing down unpaid levies. That's pretty much what that section says. It hasn't yet commenced. It hasn't started yet. And what I have heard since talking about this and some social posts on this, what I've heard is maybe, I don't know, I don't have any official intel on this, but maybe that particular section hasn't started for a reason. It is being looked at. Maybe we'll see a further amendment to that section or that part of the legislation before it begins. We're not the only ones who are confused by what that section might mean and what we're supposed to do with it. I wouldn't be surprised if we saw some change in that area. It was a little bit weird that that was the only little section with a big impact that didn't start on the 27th of October, when the rest of those sections about levies, levy recovery, payment plans, when those sections started. So have a listen to what Rena and I think about that, about some of the reforms that have commenced already, about offering payment plans. We do talk about a strata manager who we'd both heard from, who said, on, what was it, 27th, 28th, 29th, on the 30th of October, in my inbox, I received 32 requests for payment plans. Days after the legislation commenced, requests for payment plans. And remember that these requests for payment plans now must be made on a prescribed form. It has to be that form, which I shared with you a few weeks ago, that is linked on Fair Trading's website. Very simple, couple of pages, fill in the form if you are a lot owner wanting a payment plan. What has been discovered, not by me and not just by this particular strata manager I was talking to, but as I understand a few people now, the form does not have a section in it for the lot owner to put in their strata plan number. They just have to put their name and their lot number, which when you're a strata manager getting 32 requests for payment plans in one day, 1 week, maybe, that's a little tricky for you to handle and to have to trawl through your system, if you can, to match owner names and lot numbers to strata plan numbers. So as soon as I heard about that, I went and looked at the form and said, oh my gosh, I didn't notice that. Don't think others noticed that until you started getting those forms without strata plan numbers. I wrote to Fair Trading, got a very, very quick response saying, yep, Amanda, we got it, we're on it. Where you'll hear further from us. I think I'm going to say it wasn't so much we're going to fix it, but I'm pretty sure we will see, I hope we will see an amended version of that form. That is what we're talking about on the podcast this week. We also ended up, I think, in a chat about owners corporations receiving expert advice. I mentioned engineers' reports, strata committees receiving engineers' reports that tell them what work needs to be done on the common property quite clearly, scope of work. This is what needs to be done to fix the problem, whether it's a leaky roof, a leaky bathroom, leaky window. This is what needs to be done. And strata committees saying, but that's really expensive and we can't afford that. So we're not going to do it. And leaving suffering lot owners in wet, moldy, leaking buildings. I let you know my thoughts in this week's podcast episode on that, and you've got a little snippet of my thoughts on that here on the page. Quite a popular little video that we posted here on the page this week. In short, too expensive is not a legal defense, and that has really struck a chord with so many of you. There are some comments there under that video saying, this is me, this is my situation, this is what I'm suffering with at this moment, having to go to the tribunal because the owners corporation will not do what their own engineer is telling them they need to do. From my experience as a strata lawyer, those are pretty open and shut cases in the tribunal. And that's how it came up. In the podcast episode, I was sharing a win from one of my clients and a member inside the Your Strata Property online membership community. She had self-represented, running her own case, simply going to the tribunal saying, I want the owners corporation to do what its own engineer has said it needs to do to my bathroom. Ultimately, the owners corporation made that offer by way of settlement. Yes, we will do that work. Tribunal proceedings resolved. Happy lot owner. Unfortunate that this owner had to go to that extent of commencing tribunal proceedings to get the owners corporation to meet their legal obligations. So that's a lot about this week's podcast episode. Scrolling over to those comments, Colin is saying, show me any building in Sydney that has changed strata manager, building manager, lawyer, or chairman that has full records, and I will shout you a free wine. Yeah, it's a big problem. Records walking away with those professionals or those people when they change, strata managers in particular. We lose a lot of records, I think, when management changes, because not everything's saved on that system that then becomes part of the download and part of the handover. It's definitely a big problem. David, I think, is talking about the frustrations with AI. David telling me I had someone quote me a section from the Companies Act. I thought, that's weird. It's called the Corporations Act. Turned out to be the Indian Companies Act that they had Googled. Yeah, there you go. You've got to have that extra part of your brain switched on, right, to be on top of this. We're going to get into this in a little bit more detail in probably 60 seconds or so. But we have to be alert now. So many times I have, in the last couple of years, I'm going to say, received emails from my clients, my own clients, posts in the forum, our member forum, where I am being told, Amanda, what about this case? Or what about this case? Or doesn't this case contradict what you've advised me? And, even I, 20 years in, have a little panic. Oh, I didn't know about that case. Where did that case come from? I haven't heard about that case. And I'll show you what it is that I do to check. When I have that momentary panic, take a breath. What do I do to check whether that case is real or not? Because I've learned now that usually I'm pretty across things. There's always new cases that we may not know about. But when you're being told by a client that there is a leading Court of Appeal case on this particular issue that says exactly the opposite to what I have advised, it's probably worth doing a little looking into. So I'll share with you in a moment how we do that. Hey, Peter, it's good to have you here. Philip saying, we are so scared that not only we offer payment plans, we automatically put the debtors on provisional 12-month payment plans. Yeah, really interesting to hear, Philip. And you'll hear me say that in the podcast episode. I think that's where you need to be heading. It's sounding like, watch this space, right? We might see some further amended legislation, but it's sounding like we need to be heading to a place where if we want to be able to recover our costs when we've got recalcitrant owners who just don't pay their levies and we end up having to sue them, we're going to have to point to some point in the past where we have offered a payment plan for that debt. And please do bear in mind, again, I remind Rena of this in the podcast chat, bear in mind that there are reasons and a reasonableness test if you're going to refuse a payment plan. And if the non-payment of levies or non-payment on time of levies in full will cause the owner's corporation to not be able to meet its debts, not be able to pay its expenses on time or at all, you can refuse. You can refuse those requests for payment plans. Daryl saying, our team had a challenging AGM with a scheme where owners were complaining about how their units looked and outstanding repairs from 2 years ago, and then proceeded to try and reduce their capital works fund budget. Can't have it both ways. It's probably a line that I've said many, many times in my Strata committee member career, I'm going to say. I'm very often using those words as a Strata committee member. Can't have it both ways, guys. We want to improve the common property. We want to repair and maintain. We want to meet our legal obligations. That costs money. That costs money. The levies are going to have to go up. Jeff's loving this discussion and can relate, unfortunately. Josephine saying the incorrect citing of cases has been called out by the courts. When a strata manager gives wrong advice, you're simply told there are no strata police. Well, let's get into this. The trouble with the frustrations some of us, and I think more of us in the future, are going to be experiencing with AI, the use of AI. I know our strata managers are frustrated by this when it comes to some emails that they may be getting from owners, from committee members. Committee members, you might be frustrated. Again, if I put my committee member hat back on, I've seen a marked improvement, I'm going to say in quotes, improvement in the way that some residents, owners, others, committee members in my community are communicating. Those who previously might have found it difficult to send an email that was well structured, that had arguments that were logical, that had great spelling and grammar, all of a sudden, those emails have improved. I've noticed that difference in my own community. And as I've said, I have seen how AI is being used by my clients and by the members inside our membership community. This week I was online training a group of Strata managers, and I said to them, give me the number one thing that's trying your patience right now? And we were covering the CPD topic, psychosocial hazards in the workplace. That was the CPD topic that I was there to teach them. And, I was kind of thinking in that context, what's trying your patients right now? What's maybe causing you some stress, some anxiety, some frustration? And the first thing that came up, to my surprise, was AI, ChatGPT, the use of ChatGPT. And one of the examples was that this manager was at a general meeting in person, and there was an owner in the room who was checking everything with ChatGPT that the Strata manager was saying and calling out if ChatGPT said, no, that's not correct, or here's a case that I've just hallucinated that says you're not correct. And the Strata manager was saying, it's bad enough when we got lawyers in the room sometimes, when there's conflict and a lot owner brings along their lawyer, but now everybody's got what they think is a Strata lawyer in their pocket with their ChatGPT app, and it just slows everything down. It means that at every turn, my competence, my credibility is checked. And I have to explain myself. And it's hard when ChatGPT is saying I'm wrong, and I know that I'm not wrong. It's causing more expense. It's causing more stress for everyone. In our member forum this week, one of our members who is representing themselves in a case, I think they're standing in and representing their committee or assisting their committee to defend a case that has been brought by an owner. This member posted in our forum that they had received a case, which was a real case, from this lot owner, their opposition. The lot owner was waving around the case as something very helpful to their position. And when this committee member went and read the case, they realized that the result of the case was actually in the owner's corporation's favor. So it was not a helpful case to the lot owner at all. And this member had, as a lot of us do, you doubt yourself, you question, did I read that right? Posted the case in the forum and said, am I reading this right? I think this is actually helpful to us. I don't know why this owner has waved it around saying, here is the decision that I'm going to be relying on. I had a look at it. I said, yep, you're right. In that case, the appeal was dismissed. The owner's corporation in that case was successful. And I said, I suspect what has happened is that ChatGPT has fed up this case to this particular owner. They have just spat it back to you. You're lucky that it's even a real case and you could go and read it, but they haven't actually looked at it to see that it was helpful to them. So it's not just us. It's not just the managers and the lawyers and the committee members, and maybe you as a neighbour who is getting frustrated with this confusing, misconceived, misplaced use of artificial intelligence. The courts, as Josephine just told us, the courts, our tribunals are also getting very frustrated with this as well. And within the last week, I think it is, we have a case in the Strata context. It's called the Sky Gardens case, and it comes from an adjudicator inside the Office of the Commissioner for Body Corporate and Community Management. It's an adjudication decision. I do have a copy here, but for you, it is reported. Rach has the link here for you that she's going to share, and I'm going to pop it up here on the screen. It's a case about an air conditioning unit. That's not what I want to focus on here today. If you are in Queensland and you're interested in the law on this one, please do have a look at the substantive commentary and substantive decision on this leaky air conditioner. Water ingress to the applicant's lot from a blocked or damaged air conditioner drain The question was whether the body corporate was responsible for the repairs to the drain or the lot. And there was a question of costs because the tribunal had to determine whether the application was frivolous, vexatious, misconceived, or without substance, and whether a costs order was warranted. And what I'll show you is that this question of the applicant lot owner's use of AI became central to this question of costs. And you'll see the orders straight up here. The application was dismissed on the basis that it was misconceived and without substance. And within 30 days, the applicant had to pay the body corporate the amount of $2,000 as partial compensation for its loss arising from this application. And the tribunal does say that that's a little bit unusual to make that cost order in this kind of situation. Applications get dismissed all the time. Lot owners are self-represented. They don't necessarily know how to put together a compelling application or whether they should be putting together an application. The tribunal doesn't usually punish lot owners simply for that reason with a cost order, but in this case, a cost order was made. What I'm going to show you in this decision, and you can, as I said, read the whole thing, but I'm just taking you to the points where the tribunal was critical of the applicant's preparation of their case and why the tribunal was critical. So here at paragraph 17, and I'm saying tribunal, that's not the right terminology, the adjudicator. Let's stick to the adjudicator. Sorry, New South Wales lawyer here, where we no longer have adjudicators and everything's done in the tribunal. I know in Queensland you have that different system. So the adjudicator says, having reviewed the submitted material, I wrote to the applicant seeking clarification of several matters. I sought copies of documentation referred to in the application. I sought copies of case law cited in the application. I sought confirmation of the location of the air conditioner and drain. I also invited comment on the claim for cost. And I will note the responses below. So you can see how this system of adjudication is a little bit more informal in Queensland. Tribunal generally wouldn't be writing to parties in New South Wales seeking more information because we do everything in person, and in person includes by phone or video link these days as well. A process of adjudication is more paper driven. So the adjudicator may be asking for more information. So adjudicator says, I note at the outset the way in which the application has been presented, including repetitive and contradictory material and confusing references to the evidence, legislation, and case law. That impeded the determination of the application. And she says more about that further on in the decision, quite a bit more. So ultimately, lot owner lost the case. In this case, the application was entirely misconceived. It was not disputed that there was damage to the applicant's lot caused by the air conditioner drainage pipe, but it was in a wall that was wholly within the boundaries of the lot. So it was lot property. Body corporate was not responsible for it. The applicant had not substantiated that the wall was common property or that it was the body corporate's responsibility, or that the damage arose from something the body corporate is responsible for. That in itself, the fact that this self-represented owner did not understand the law would not by itself warrant an award of costs. They're not legally represented. They don't appear to have been previously involved in a dispute here at the Body Corporate Commissioner's office, but other matters arise regarding the applicant's pursuit of this application. The application was presented in a confusing and repetitive manner. The grounds included numerous assertions about the nature and cause of the leak and damage and statements made by others, but they were not substantiated by the evidence presented. The applicant cites quotes and reports that do not appear to exist. This is when we start to catch on, right? Or if they do, the applicant has not produced them despite my requests. The applicant cited incorrect or irrelevant provisions of the legislation on numerous occasions and mischaracterized those that were relevant. The applicant cited cases as precedent for various propositions, but those cases either do not exist or have little or no relevance to this dispute. The applicant's reply to submission cited 5 further cases in support of their position. Of those, 1 does not exist at all, 2 do not say the things the applicant asserts that they say, and 1 has a different case name and does not include the text that the applicant quoted from it. 1 case is relevant to one extent, but relates to circumstances where they're not applicable to this case. So the adjudicator is caught on. here that perhaps the applicant has been getting assistance from elsewhere. The adjudicator directly asks the applicant, did you use AI to prepare your application? They responded that portions of the application and reply were prepared using tools for assistance with grammar and document structure only, but all information, legal references, technical evidence were sourced from verified reports, invoices, and correspondence. They said they independently verified all information generated or formatted using any digital assistance. Any miscited or incomplete references were unintentional. I mean, I don't know if those were the applicant's words, but those words kind of sound like they might have come from AI themselves. So the adjudicator refers to the court's guideline. We have very similar guidelines here in our New South Wales courts and tribunal. I'm going to show you the one that is produced by NCAT. Really, really important to be aware of that, to be across that. There's warnings that AI chatbots can make up fake cases, citations, or quotes, refer to legislation that does not exist, provide incorrect or misleading information about the law. And this is the real gut punch here that this adjudicator delivers. I kind of love this. If the applicant used AI or other sources in preparing the material they submitted, I am not satisfied that they check the accuracy of the information obtained. If the applicant has not relied on AI for the contents of the submitted material, then they don't even have that excuse for the innumerable errors and misrepresentations in the application and those persisting in the reply to submissions and in the response to my queries. Oh, that's pretty clear, isn't it? And I think a key point here is that the adjudicator gave this applicant the opportunity to correct these errors, to admit that these cases weren't real. That didn't happen. Things only got worse. I'm satisfied the application is misconceived and without substance. I consider the scale of the deficiencies in the submitted material amounts to an abuse of process. Pretty serious finding. The body corporate has been put to considerable expense responding to this application. The resources of this office have also been wasted. I'm satisfied that an award of costs is warranted. So $2,000 in costs that this applicant needed to pay to the body corporate. This is one to remember. And if you are a strata manager, perhaps, who might be receiving very obviously incorrect emails, citing incorrect cases and case law, maybe you want to flick this one over to say, look, it's quite clear to me that you are using generative AI to produce these comments, this correspondence. It may be helpful for you to review this case to see where that type of communication may end up if you're going to continue down that path. What do you think, guys? There's a few comments here in the chat. Just looking over to a comment from Ready Strata, which may be relevant to what we spoke about earlier. We appreciate that most committees will assume that sending an email creates a recorded decision. The reality is that the only true record of the owner's corporation is the published minute book, and the legislation dictates the process of decision-making through duly convened meetings. Strata managers dance on the fence line of legislation, accepting emails as decisions of the committee while we try to appease our clients. I don't think I can see the whole of that comment there, Ready Strata, but that is sounding pretty on point to me. Thank you for sharing that. I can see Suzanne there agreeing with you. Philip saying, I'm wondering if there's a way to search all NCAT and court reasons for decisions, not only those available on case law and online registry. So Philip, great question. If you can't find an NCAT decision on New South Wales case law or OSLI, then it is not a reported decision. And you can't get it. So we only have access to reported decisions. If you're searching online and you're looking at those case databases, I've said two of them, Case Law New South Wales, for New South Wales cases, OSLI as well. There are other paid services. But if a case is not reported, and many NCAT, particularly strata decisions, are not reported, you can't get it. It doesn't. There's a decision that the parties have, and often a detailed written decision that the parties have, and it's on the file at NCAT, but it's not publicly accessible. You can sometimes get these unreported cases from me here because this community so generously shares cases with me, and the great ones that I think many of us can learn from, I bring here to these live chats and I make available to you. I can do that. But if you don't otherwise have access to a written decision from a party, then no, it's hard, if not impossible, because you don't otherwise get access to the files at NCAT to get these cases. It's a big problem. The lawyers have complained about it for quite some time. We would love to see more reported NCAT cases. Sean saying, all too regular an occurrence. This case, this use of AI. David saying, surprised that the cost of the war was not greater. Must have cost the body corporate much more. Yeah, the point is made in the decision that is a proportion of the actual costs that the body corporate suffered, was burdened with. Let me take you over to the New South Wales Civil and Administrative Tribunal Procedural Direction number 7. You might have seen there this adjudicator referring to guidance from courts. I don't know if there is similar procedural directions for the Commissioner's Office and for those adjudications. There may be now, but we definitely have some rules about this and rules about the use of generative AI in New South Wales, in the New South Wales Tribunal, and certainly the courts as well. But right now I'm going to focus on the Tribunal because that's where many of us are ending up at the moment. I will just pull this document here for you and share it on the screen. We have a link to it, I believe. Rach, if you want to pop that in the comments, and I've just marked up some relevant parts of this procedural direction that I want to draw your attention to and talk a little bit more about. So this started on the 7th of April, 2025, and these procedural directions are updated regularly. And I think this one in particular will probably be regularly updated as the tech changes. Please do be across this. If you are a lawyer, if you're a strata manager, if you're a community member, if you're an owner litigating or thinking about litigating in the tribunal, these directions must be complied with. For the avoidance of doubt, for the purposes of this procedural direction, generative AI, so it's all about generative AI, but we're not talking about tech that is just going to correct spelling or grammar or provide transcription or translation, formatting. We're talking about tech that generates substantive content. So we're talking about these large language models like our chat GPTs, which is probably most familiar to most people. Parties and their legal representatives should be aware of the limits, the risks, and the shortcomings of any particular generative AI program. It can include all of these things we've already been talking about: hallucinations, making up fake cases, biased or inaccurate output, lack of safeguards to preserve confidentiality. This is a big one when we're talking about our communities and personal information and litigation that we're involved in that may involve a lot of financial documents, personal documents, emails. You should not be feeding that information into a system that is not secure. I'm not a tech person. I don't profess to understand the ins and outs of a chat GPT, for example, but certainly I would not be feeding my clients confidential information into a chat GPT. There is dedicated software out there that lawyers are using. I'm sure strata managers are using as well, other professionals that we pay for. We pay for these services to provide a secure platform to assist us with the work that we do for our clients. That's different. That's different when you've got all the safety and the security and confidentiality and assurances for that particular software that you might be investing in. That is not, as far as I'm aware, in my opinion, that is not ChatGPT. So feeding all that private information that might be about you or your neighbors or your community into ChatGPT is probably not going to be a good idea. Be aware that the material you're feeding into some of these models may be used to train that model, potentially making confidential information available to others. Okay, so this is the general prohibition. The following categories of information must not be entered into any generative AI program. Information subject to non-disclosure, non-publication, confidentiality orders being made by the tribunal. We're not then putting that information into ChatGPT. Unless you're satisfied that this is a controlled environment. You may use generative AI for chronologies, indexes, witness lists, preparation of briefs, summarizing or review of documents and transcripts, the preparation of written submissions or summaries, but be careful, and this is subject to some directions that appear further below. This is important. Generative AI must not be used in generating the content of statements, affidavits, statutory declarations, character references, or other material that is intended to reflect the evidence of the maker of the statement or deponent of the affidavit, or the witness's evidence or opinion or other material tendered in evidence. Your affidavit needs to be your words. Your witness statement needs to be your words. It is your experience. It is not something that ChatGPT can or should be writing for you. And this applies to lawyers who are helping clients with affidavits as well. The rule is always that the lawyer doesn't write the affidavit. The client needs to write the draft of their statement, the set out their experience, and the lawyer can help them to make sure that that's in an admissible form and that they've covered all the facts that the lawyer thinks they should cover. But the affidavit should always be in the words of, come from the mind of the maker of the affidavit. So using artificial intelligence to draft up an affidavit is a big no-no, and it is a breach of this procedural direction. In exceptional cases, leave can be sought to use generative AI in preparing an attachment, an annexure, or an exhibit, but you need the permission of the tribunal to do that. Where you might have used generative AI in submissions or summaries of arguments, then you have to say so. You have to verify in the body of the submissions or summaries that all citations, legal and academic authority, case law, and legislative references exist, are accurate, and are relevant to the proceeding. So you got to check it. You got to check it and say that you have checked it. Make similar verification in relation to evidence written in submissions or summaries of argument. And you can't verify using AI, right? Okay, so just be careful to using AI to verify that everything is right. This is a really important procedural direction. There's a comment there about expert reports as well. We don't want to be using Gen AI to draft our expert reports. I hope that goes without saying. If you haven't come across this one yet, get your hands on it. I believe we've got a link for you. It's there on the NCAT webpage. You may have similar direct procedural directions in your tribunals in your various states. We certainly have them for our state courts as well. And what I'm starting to see the lawyers do in affidavits that they're filing for their clients, they're having their client make a statement in the affidavit, have a paragraph in the affidavit that says something along the lines of, no part of this affidavit was prepared using generative AI. As I read that practice direction, that's not a requirement to say that in the affidavit, but might be a good idea to be very clear that you haven't used generative AI in preparing your affidavit. So you can use it for chronologies. So using it for chronologies, and I have found that particularly helpful using a software that I pay for to assist my legal practice, using it for chronologies where you've got lots and lots of documents, to be able to order those documents for you and produce a chronology of what's happened over time. And then that's often the starting point for drafting an affidavit. As a lawyer, you'll prepare a chronology and then have your client go through that chronology and draft their version of events based on what's happened in the past. So that can be very helpful to have the use of AI there for producing chronologies, but don't use it to draft your affidavits, your witness statements, any references, character references. That would be a breach of the NCAT procedural direction. Be very careful using it for submissions. You want to check the law, check the case references. I want to show you what I do to check, and what I have done as recently as this week, when I was given a list of cases from a very well-meaning, and I want to say I'm very sympathetic to this, and I do want to be gentle with you, those who are using AI to help your lawyers. Very, very well-meaning. But when I get a list of cases from a client saying, "Hey, Amanda, are you aware of these cases?" It can end up costing you more money to send us off on a bit of a wild goose chase. But I want to share with you here what I do when I receive that. And as our managers, our owners, you may want to do this too when you are receiving correspondence, let's say, and you want to check the truthfulness of that or the accuracy of that, I'm going to share what I've got here on my other screen with you. Okay, so this week I was presented with a list of cases from a client. I had a feeling looking at it, I don't think these are real cases. I pulled the cases out into a separate document, so there was no personal information in that document. And I did ask the AI to please perform a structured check of the cases in the attached document and identify cases which you cannot locate at all or reliably verify and which seem suspect, inaccurate, or hallucinatory. So I asked it to do that. And remember, I said, we don't want to use AI to be verifying, okay? We don't want AI to check its own work. Not cool. But if you're in a rush and you just think, you know, somebody sent me this, I don't think it's real. This is not necessarily for the tribunal. Ask the AI if they can check it for you. That's what I did. And here's what the AI came up with. That's going to be quite small on your screen, I appreciate. But in short, these were the cases that had been sent to me. And you can just see here, they look real. They look like real cases. And this is what the large language model is doing. It's actually pulling, in a lot of ways, strata plan numbers and names that are from real cases, and sometimes citations that are from real cases, but then they've got the wrong names. And here you will find every case that I was sent but one. The AI has gone back and told me, yeah, that's not verified, looks wrong, likely inaccurate, looks wrong. And when the AI tells me why it's wrong, I'm being told that the citation exists, but it's a different case. That's irrelevant. Couldn't locate any NCAT decision with that exact party. The citation is correct, but different parties, different year. The name, so Yao is a famous strata case. Shahid is a well-known, there you go, well-known strata case, but when you put the case together with the numbers, not a real case and not relevant to the issue that I'm working on at the moment. A better way to do this is a quick verification that the AI can do for you if you're a strata manager or a lawyer or you're a committee member wanting to respond to some strange correspondence you might have received. Yeah, maybe you can ask the AI to do this for you. Another way to do it, and I also did this before getting back to my client and saying, I don't think these are real cases. I actually took one of the citations that I was given in the email, and I don't know if this will work. I'll share another screen for you. I popped it into Google, and I'll show you what comes up when we do that. Oh, I have you all in suspense now. Okay, I'll do it this way. All right, so I've copied the case name. I've popped it in here into Google. And the black may not be ideal here, but I've seen what comes up. This is Thompson and the owners, 57987. Is this a real case? First of all, you might think immediately, maybe it is, because there's a website here that maybe talks about it. You can see here the case is 2021. Google's telling me that this article from Kieran Benson Lawyers is from 2017. So it's probably unlikely that it mentions this case. I won't drag you through it, but I did go into that website, and that website says nothing about this case because it just doesn't exist. As you scroll through Google, you'll see here that Google will show up that these words, it's found these words somewhere, some of these words, but it hasn't found this. In NCAT published decisions, it's found a case that maybe has the owners, these words in it, but it doesn't have these words in it. So that case is not going to be there. We've got lawyers who are talking about similar topics, but these words are not there. The actual case and the strata plan number are not there on that page. And this just goes on and on. You'll see these words are not there. Another example of this, if I go back to my document, I won't drag you through it. But another case example where I copied one of those case names and popped it into Google, literally nothing came up. Nothing came up at all. So very unlikely that that case exists. And remember what I said earlier, we can only access these as reported cases. Unless you're a member or you've been here on a Friday Live and you've grabbed one of these unreported cases I've shared. If you're putting the citation into Google and nothing is coming up, then it is almost certain, I'm going to say almost certain, that this case does not exist. So those are some ways that you can check if what you are being fed is real. You can ask the AI to check, but please be careful. I strongly recommend you do your own research, and it's not hard. If these are real cases, they're going to be mentioned somewhere on the World Wide Web. They're going to be there. It's very unusual for the maybe even impossible for the AI to be feeding up unreported real cases. So if you can't get your hand on the case and read it, and please read it and see that it's relevant to the argument you want to make and supports you, because that was another criticism in the adjudication decision. Remember, the adjudicator said in some of the cases that were real were not authorities for the principle that the applicant was trying to establish, and some of them were against the applicant's interests. We definitely don't want to be relying on cases like that. Philip's giving me a section of the UCPR, the Uniform Civil Procedure rules there. Is that about the use of AI now, Philip? I'll go and have a look at that one. Colin saying, seeing AI being used to translate into other languages, which are hard to check and are sometimes blind to the sender. Yeah, that would be tricky. That would be tricky, I think, Colin. Josephine, going back to our adjudication case, saying, so the owner didn't believe the committee that the aircon was their own responsibility. Yeah, I suspect that was the case. Quite possible that the owner just wasn't reading a lot of the stuff that they were being sent by their body corporate and even by the adjudicator, Josephine, because not just the adjudicator was saying these cases are not real. I believe the body corporate was saying the same as well. All right. So that's what I wanted to share with you today about the Sky Gardens case. Definitely a word of caution there for our Strata space, for our owners, for our Strata managers, for our committees. If you are involved in, thinking about, even if you've just come through tribunal litigation, especially litigation in our New South Wales Civil and Administrative Tribunal, I encourage you to attend my next free online training. It is the Strategic Strata Litigator webinar, the most popular free training that I have ever delivered. We only roll this out a couple of times a year. It's all about how to navigate NCAT, the New South Wales Civil and Administrative Tribunal, end to end, without expensive legal fees, even if you may have lost faith in the system. I will be running this one live via Zoom webinar, not here on Facebook, live via Zoom webinar on Thursday, the 20th of November at midday. You can join me free live for this 90-minute session where I'm going to share what it takes to craft a winning argument before the tribunal, especially when you are representing yourself. I'm answering your questions about the practicalities and processes of NCAT in particular, and helping you to find your way through that web that is litigation with the least expense and the best chance of success. A number of you have done this webinar with me before. You have then gone on to win or successfully defend your NCAT cases. Some of you have told me that you have saved tens of thousands of dollars in legal fees with what you have learned on this webinar and with the ongoing support that is available to you after the webinar. So if you haven't been on this one, and even if you have joined this webinar before, there is always something new that I'm sharing. This whole world of AI is new. Do join us on Thursday, the 20th of November at midday. The place to go to register is yourstrataproperty.com.au/webinar. Really easy for you. Rach also has a direct link to the registration page that she's going to pop into the comments here for you, the Strategic Strata Litigator webinar. I'd love to see as many of you online with me on Thursday, the 20th of November as possible. It's always so much fun. And if you have specific questions about the tribunal process, I've seen some of those questions on the page, and this is part of the reason why I want to roll this out. Just last week talking to Rena about so many people are in the tribunal now. When I post anything on socials about litigation, about problems that owners might be having getting their owners corporations to fix the common property, inevitably there's a number of comments. Yes, I'm in the tribunal about this. Oh, I'm going to have to sue my owners corporation about this. I know that you need help. If you want to pop those questions, pop them in here in the comments. I always come back around and check those comments. You can reach out to us by private message on the Facebook page as well. What is it that you need to know about tribunal practice and procedure that I can cover for you on the next Strategic Strata Litigator webinar? So yourstrataproperty.com.au/webinar is the place to go to sign up for that free online training. Jan is saying, what a great idea. Thank you. I want to come on 20 November. I hope to see you there. Jan, you are most welcome. That's all I got for you. Thank you very much for joining us this Friday for our Friday Live. It's been lovely to spend time with you and to share some Strata updates and some Strata lessons with you all. Have a fantastic weekend, whether you're in or out of Strata, and I'll look forward to catching up with you all soon. Some of you hopefully on our 20 November Strategic Strata Litigator webinar. See you then. Bye for now.